what's your name, sir?
Colonel McCreary, capital arrest, lowercase. Not the all caps, sir. Which legally denotes a corporation.
Thank you, sir. I'm not the typist around here, sir, so we're going to go with it the way it's spelled.
May I please address the court, sir?
Sir, I'm sure your counsel would suggest that you not do that, but you have a right to do that if you want to over your counsel's very solid legal advice.
Judge, if I may briefly, for the record, Mr. McCreary did not want us to represent him. We tried to represent him. We would like to help him represent him.
I would like to represent myself, sir. Under Michigan Constitution 63 Articles 13, represent myself, Judge.
All right, sir. It appears that you have a desire to represent yourself. Let me just ask you a few questions. You're aware that either right now or at any point while this case is pending, you can have the assistance of counsel should you so desire. Are you aware of that?
I am aware, sir.
All right, and it's your decision at this time to proceed without counsel, is that correct?
That's correct, sir. Appropriate persona under Michigan Constitution 1963, Article 13, sir.
All right.
I am very well versed in law.
Hold on, sir. Hold on. While you do have a right to represent yourself, you do not have the right to talk over me, sir. So let me say a few more things. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, which we've just discussed. And if you cannot afford an attorney, the court will provide one for you. In fact, we have several attorneys here today who are very capable. Of course, you can turn down that constitutional right, and it appears that that's what you're doing. Let's see. You're charged here with one count of misdemeanor assault or assault and battery. Maximum penalty is 90 days and or $500. And of course, going to enter a not guilty plea on your behalf, sir. We're going to hear a few words from the prosecutor, and then it'll be your opportunity to speak if you so desire. Mr. Prosecutor.
Thanks, Your Honor. Again, Steve Vincent on behalf of the people. The complaining witness, Your Honor, in this case is a police officer. Apparently, during prisoner transport, the defendant walked past the police officer who was in and around the area while the defendant was being escorted to the holding cell, and defendant took it upon himself to lean towards the police officer and spit on him. As a result of the defendant's actions, the people will be asking for $1,000 cash bond.
Mr. McCreary, anything you want to say as to bond, sir? I do caution you not to discuss the alleged facts of the case, but it's up to you.
Well, I first would like to challenge personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. This is a structural error, Your Honor. Under MCL 767.24, Judge, this statute of limitations has told this is a structural error. This is prosecutorial misconduct under Michigan Michigan Rules of Professional Conduct 3.8, sir. I was in the Department of Corrections from, I believe it was I know it was 2002. I was released in August of 16. Paperwork, everything. I've been filing complaints against the prosecutor's office. Kim Worthy, where a judge heard it on appeal, Kirsten Frank Kelly. It's been crimes against me by the prosecutor's office. And I would like to move for a change of venue where it's clearly documented, Your Honor. And the statute of limitations has told, I don't know nothing about this case. Why wasn't I processed or liens checked before I was released from prison? I've been home 6.5 years, Your Honor. This is a crime in violation of misconduct in office, MCL 750.505. Also 18 USC 241, 242 per the federal statute. Embler versus Patchman, the prosecutor does not have absolute immunity. Judge, and I exercise the common law. I demand that this case be heard under the common law, Judge. I've been home 6.5 years. No threat to anyone. I've been working. I have had 5 children since I've been home. I'm a grandfather. I have 2 grandchildren, one on the way. And I've been trying my best, and people have been calling, making false complaints on me, and it's well documented. I've tried to press charges, and the prosecutor won't do anything. This is selective prosecution, vindictive prosecution as well. It's all documented, sir. And I asked that this case, I would like again to challenge personal subject matter and territorial jurisdiction. Under MCL 767.24, the statute of limitations have told. They have been notified of any pending warrants or anything else while I was incarcerated before I was released. I've been home 6.5 years, haven't been a threat to the community, haven't been a threat to anyone. People have made false complaints on me, and I filed police reports with the Department of Justice, the FBI, the state police, and DPD, the 10th precinct. And it's documented, and they don't want to let me press charges. This is selective prosecution, Judge. So
Thank
I
you,
asked
sir,
for
for your-
dismissal.
All right, motion to dismiss is denied. I don't have the authority to dismiss the case. The issues you raised, sir, are more properly brought before the judge who's going to hear this case, which will be Judge Bryant, and you can raise those issues at your next hearing. What I will do at this time is set bond as follows. Counsel, what was your request?
People were requesting $1,000 cash as a result of the actions in this case.
Okay.
I object. He just said $1,000. He's being vindictive, Your Honor. I
Sir,
object.
do you have any financial means with which to post a bond of any type today?
I have $300 on one credit card, and I have $40 on another card, sir. And I'll be more than happy to give you whatever I have. I've been trying, Judge. I have tenants. I have my home. I have kids I need to get home. I haven't been a threat to the community. People have been lying on me, Judge. And it's well documented, man. And I told myself on personal court. And again, I object under UCC 1-308. I reserve my rights not to be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily, and intentionally. Furthermore, I do not accept the liability of revealed contracts. Also, I would like to cite a case to the court, Foy versus City of Berea, 58 Federal Third.
Sir, I don't mean to cut you off, but I do not have the authority to dismiss as you requested. So it doesn't do you any good to give me all the citations. You can raise all of that with Judge Bryant on your next court date, okay? So court's going to set bond at $1,000, 10%. That'll be $100 to you, sir, which you've indicated is an affordable bond.
I got my card.
Yeah.
Yes, sir.
If for whatever reason you don't post, you'll have an affordable bond hearing tomorrow morning. But if you do post, you don't have to worry about tomorrow morning. Your next court date will be in front of Judge Bryant on June the 7th here in 36th District Court for a pretrial, and I'm sure that she will entertain your motions at that time. Thank you, sir.
Can I ask you a question?
Thank you.
Sure.
Can I ask you a question?
Sure.
Can I ask you a question?
Go ahead.
Your Honor?
Yes, sir. Go right ahead.
I would like to state this, that the prosecutor is under oath under Article 6, Section 3. Right now, they're violating their oath. There is a case called U.S. versus Will, where they have jurisdiction to act and they don't act. And if they don't have jurisdiction to act, it's treason against the U.S. Constitution, sir, under the common law.
Okay.
I ask that you send this matter to the Michigan Attorney Grievance Commission, Judge, because of misconduct on Kim Worthy and her subordinates.
Okay, sir. Again, that's something you can raise with Judge Bryant when you see her in June. Also, with regard to the bond redetermination date, that will be Wednesday, should you not post. If you post, you don't have to worry about it. If you don't post, that will be bond redetermination on Wednesday morning in front of Judge McConico here in 36th District Court. Thank you, sir.
I use my credit card. When you okay. You say what now? When you I can't. Oh, can I ask somebody to call somebody to post? Somebody post up here. Okay. Yeah. Yeah. I don't know how this stuff works. I'm new to this, so I'm 50.
Okay, well, sir, hold on now. You was okay. Okay. Just okay. Mr. McCreary, your name?
Ernell Michael McCreary, ill, all lowercase, not the all caps corporation.
Nobody writes the name in all caps. All right. So today is the date set for a pretrial conference. And Mr. McCreary, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McCreary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
I would like to challenge the plenary jurisdiction of this court as outlined by state Supreme Court.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know as it relates to this pretrial conference where you've indicated that you want to represent yourself. It is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court. With all
You're going to be restrained every time you go off course. So
well,
understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCreary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once this
motion is denied, anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCreary and ask him how does he wish to proceed with the hearing for Mr. McCreary.
Yes, Your Honor.
In code of judicial conduct, judge. And I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCreary, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McCreary. Thank you, Mr. McCreary.
Yes, ma'am.
Your Honor.
Yes, sir.
They indicated that he would need to file a motion for recusal before you. And if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date.
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McCreary, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is not?
Sir, if you just, I promise you, I've been on the bench for 16 years. And I promise you, if you just let me talk, I mean, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom, and my courtroom phone number is 313. And you will speak with the clerk. Make sure the clerk has your current contact information so that the Chief Judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Oh, can I speak or no?
Oh, well, what else is there, Mr. McCreary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McCreary, I don't take things personally. Ms. McCreary, let me say something to you. So since we talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And
correct.
Maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed. And so I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a Black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old Black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McCreary, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Oh, yeah.